to these opening comments by principle on the case of Peter Nolan versus Jennifer Toal. I just wanted to add some opening comments to this presentation that you are about to see so that you can understand a little bit about what's going on. Of course, you will get into the detail as the evidence is presented, but the summary is that Jennifer Toal and I were together for 23 years, from the time that I was 20 to 43 and she was 21. We knew each other as children. Unfortunately, in divorce, Jennifer chose to commit a whole series of crimes against me, which most distressed me and which was most unfortunate. The greatest distress I had out of this was that the money that might have been used to put our children through university instead went to lawyers. However, we should probably get that money back from those lawyers. The main issue that I saw with the whole divorce process was that indeed the family courts are nothing but a criminal cartel, and they're there to destroy families, not to transition them through, quote, difficult times or anything else like that. The family law we have in places like Australia and Ireland is based on Bolshevik family law, which was directly intended to destroy the family so it could be replaced by the state. In coming to understand that the governments and the legal systems, etc., were criminal cartels, I took it upon myself to use my cases to address the issues of the criminality of the governments and the legal fraternity. So what you're about to see is not just a case of a man who is dealing with an ex-wife who likes to commit crimes. What you're about to see is a case of a man who noticed that many men were dying, many children were left fatherless, that the governments themselves were doing this deliberately with malice of forethought through the legislative systems and the legal systems. And this is really the first major case of one man's attempt to stop this level of criminality. So as you listen to this case, please keep in mind this is not about Peter Nolan versus Jennifer Toal. This is about Peter Nolan using the case against Jennifer Toal to demonstrate and reveal that the family law system in Australia, in this case, and also in Ireland, because there is much evidence presented here from Ireland, are criminal cartels, and this needs to be stopped. And the way to stop it is to create a judicial system, a system of courts and law outside the control of the government. The government has no place in running courts of law. As anybody can see from the evidence being presented, the government has fallen down on the job and has, well, not so much fallen down on the job as deliberately criminalised the legal system. Indeed, in Ireland, the, quote, Minister for Justice, unquote, Alan Shatter, openly claims that he has nothing to do with what goes on in the courts. So how the Minister for Justice can have nothing to do with what goes on in the courts is quite beyond me. Why he claims he has no responsibility for criminal actions by judges, why the entire government of Ireland has no formal procedure to deal with crimes being committed by judges, demonstrates clearly that the Minister for Justice, who happens to be an ex-lawyer, is looking after his mates in the legal fraternity, the law society. So sit back, relax. This is quite long, it's quite detailed, but you need all this information to make up your mind about what it is you're going to say about what happened in this case. And one last thing I would like to say to those of you on the jury, thank you very much for being willing to review this case and judge it. It's very much appreciated. Thank you very much for listening. Hello and welcome to this reading of the lawful notice to Jennifer Toal for the affidavit of accusation for the crimes that she has committed against me, Peter Andrew of the Nolan family. This is quite a long affidavit, and so you will have noticed that the video stream is broken into parts. And so what we will do is we'll have a number of parts to split this up. so that you, the jury, and anybody in the public who wishes to view this information can go through each separate part and know which part that you are up to. So we're going to break the parts in logical breaks. So without further ado, I will begin reading this affidavit into the public record to be presented to the jury. It is being read in under oath, penalty of perjury, and full commercial liability as an affidavit. So, from the free man commonly called Peter Andrew Nolan, standing in God's kingdom, in care of Instant Business Intelligence, 17 CA Rossetti, 2nd District, Bucharest, Romania, fax and email supplied. Lawful notice to respondent, being the human being calling herself Jennifer Marguerite Toal. I don't know Jennifer's current residential address, so I'm delivering it in care of William Toal, 23 Fernley Road, Toby Park, Wagga Wagga, New South Wales 2650, Australia. Phone number and email address supplied. I may or may not deliver the physical piece of paper. 13th of April 2013, which is today. I'm going to go through the same explanatory notes. To the public who may be reading this affidavit of accusation and not knowing what is happening, the so-called courts of law in Australia are a criminal cartel meant to make slaves of the Australian people. This has been well proven, and the evidence is presented on the Crimes Against Fathers Australia website for anyone who would like to determine the veracity of that statement for themselves. In the face of the criminality of the courts and the government, I, Peter Andrew of the Nolan family, and my colleagues have made efforts over the last 5 years to introduce new and proper courts of law into Australia so as to reintroduce the rule of law in Australia. My colleagues and I have received little support from the common Australian people, who seem to prefer to remain ignorant of the situation in which they find themselves, rather than to educate themselves on this matter. By such willful ignorance, most Australians have waived any right to have any say in how those of us who have been risking our lives propose to reintroduce the rule of law onto the land known as Australia. If you wanted to say, you were well advised to speak sooner. In April 2011, new courts were proclaimed into existence with 29 signatories on the proclamation. The prerequisite needed was 25. These courts were nominally called the People's Courts of Australia. It was expected that soon after, a secretary for the People's Courts of Australia in Sydney would be found and we could begin running our first cases. As matters transpired, no man came forward to fill this position in Sydney for fear of persecution by the criminals in the government. Eventually a man came forward to fill this position in Melbourne. Since I was being slandered by one Chris Merritt, who lives in Victoria, I decided to run the first case of the People's Courts of Australia in Melbourne, and for Chris Merritt's very simple slander case to be the test case. It is an open and shut case. Chris Merritt does not deny slandering me. However, Asia, who I will remind you are your servants, whom you pay with your tax dollars, making you their master and responsible for their actions, decided to pay a visit to our first secretary and to harass him and intimidate him. Since so little support was forthcoming from the Australian public for this man, he has well-founded fears for his freedom. Other men have been jailed, Ian Henke for example. Based on this harassment and intimidation, I am now launching the Men's Business Association Law Services, which offers the MBA Law Courts as a service. The MBA Law Services is a global service that operates in natural law and common law jurisdictions. If you want to know more, there is a lengthy video on this link supplied, so you can go click on it. As the founder of the Men's Business Association, I claim the right to allow MBA law courts to operate in such a way that the jury members and secretary can remain anonymous to the public so long as all evidence is presented to the public for review. In this way, the veracity of the jury trial process can be maintained in the face of clear criminality of the Australian federal government, particularly the secret police thugs who go by the general name of ASIO. You, as a member of the public, are invited to observe this process so that you too are sure the due process of law was followed, and that Chris Merritt was given a fair trial. So you can watch the Chris Merritt case. This is the Jennifer Nolan case. So I've forgotten to update this section. The purpose of this process is to ensure the due process of law is followed and that Jennifer Marguerite Toal gets a fair trial. The only way to do that is to do it in the open view of the public and not risk the lives of those who are brave enough to be jury members or secretaries of the courts. So my apologies for not getting those updates right. And you can see I've signed that 2013 2013-04-13. So again, lawful notice to respondent, the human being calling herself Jennifer Marguerite Toal, in care of William Toal, 23 Fernley Road, Turvey Park, Wagga Wagga, New South Wales, 2650, Australia. Telephone and email supplied. 13th of April 2013. Let right be done, though the heavens should fall. Notice to principal is notice to agent. Notice to agent is notice to principal. I, commonly addressed by the calling of Peter Andrew of the Nolan family or Joshua Brandon of the Bowen family, hereinafter referred to as principal in my correct public capacity as beneficiary of the original jurisdiction, being of majority in age, competent to testify, a self-realised and free sentient man, my yes be yes, my no be no, do state that the truths and facts herein are of first-hand personal knowledge, true, correct and complete, not just true and correct, certain and not misleading, so help me God. This notice is addressed to the human being calling herself Jennifer Marguerite Toal, herein also referred to as the respondent. This is an affidavit with respect to the crimes of perjury, kidnapping, extortion and theft against the man known as Peter Andrew of the Nolan family by one Jennifer Marguerite Toal. Item 1. Principal is of legal age and competent to testify. Item 2. Principal has first-hand knowledge of the facts stated herein. Item 3. Principal makes oath that on the 9th of November 2007, respondent affixed her signature on an affidavit that was sworn under oath and penalty of perjury and full commercial liability. There were a number of later affidavits, and these are all reproduced in the attachment provided. The jury may refer to the attached item named Z01 Jennifer Toal Perjurous Court Documents.pdf to see the proof of this statement. So in that PDF you can see facts of the original affidavits. Item 4. Principal makes oath that on that affidavit respondent deliberately, with malice of forethought, vindictiveness, and intention of causing injury, harm and loss, did make false statements knowingly, willingly, without coercion or other implication of pressure. Item 5. Principal makes oath that at a later date, the approximate time being late November 2007, the principal was speaking with the respondent on the telephone. The principal did challenge respondent on the point of the perjury the respondent had committed. The respondent laughed and said, quote, "Perjury is just a negotiating tactic," unquote. Okay, I'm saying that under oath. That telephone call happened. Item 6. Principal makes oath that the following statements in said collection of affidavits are false and constitute the crimes of slander and perjury with intent to cause injury, harm and loss, and in the end did result in injury, harm and loss. Principal makes the following comments on the false statements made in the referred to affidavits. 1. Principal denies committing adultery. 2. Principal denies he ever committed instances of violence against respondent. A. Principal makes oath that the incident in question at Easter 1917 was a false allegation. The respondent admitted this was a false allegation in a magistrate's court under oath. Respondent also admitted the allegation was false to the arresting officers in front of our then teenage children, Jared Robinson and Kristen Robinson. B. Principal makes oath that as he was being assaulted and severely injured and unlawfully kidnapped by the arresting officers, that respondent begged the police officers to release principal, saying that this was, quote, "all my fault and a terrible mistake," unquote. C. Principal makes oath that respondent made oath in the magistrate's court that she had made false allegations and had made oath to never again make the claim that this false allegation was true. D. Principal makes oath that in making this false allegation again, under oath, respondent has committed perjury from her prior claim of Easter in 1997, under oath that she would never again make claim that this false allegation of violence was anything but a false allegation on her part. E. The specific claim, quote, on one occasion, the respondent, meaning this principal, was arrested when he tried to hit applicant, this respondent, with a wine bottle, is a blatant lie and does not suffer even the most modest of investigation and logic. Principal, meaning me, is 187 centimeters tall, that's 6 feet and half an inch. I am 100 kilograms, which I think is about 17 stone in the old speak, I'm not quite sure. It's about 225 pounds, whatever that is. So I'm over 6 feet and 225 pounds, meaning 187 centimeters tall and 100 kilograms. And I keep in shape. Respondent is 164 centimeters tall and at that time about 60 kilograms. The very notion that principal could, quote, try and hit the respondent with a wine bottle, unquote, and somehow not do so is ludicrous in the extreme. Okay? I deny that and I say it's ludicrous in the extreme. Given the very significant size and strength difference, should principal, meaning me, have wished to hit respondent with a wine bottle, principal would have done so. This specific claim is nothing but perjury and slander of my good name. A perjury and slander that I shall demand is publicly retracted in video, since it is clear that a retraction and oath in a magistrate's court was not sufficient for this criminal woman to be held to her oaths. So I want to make that clear. Jennifer retracted this claim under oath in the, I think it was a New South Wales Magistrates Court, and the magistrate accepted that she would never again claim that this situation was an act of violence on my part. So she committed perjury in making this affidavit. She committed perjury in this affidavit, and she committed perjury against her prior oath that she would never make that claim again. So since this woman, this criminal woman, cannot be relied on to uphold her oaths made in a court, she is going to be compelled to make a video and place that video on YouTube, and she is going to be compelled to deny all the slander that she committed, that she made, and all the perjury committed in these affidavits. I will accept nothing less than a video of her recanting this so that I can post it, so that the slander and perjury that she made of my good name over the last 5 years is retracted. Okay, publicly retracted. 3. Principal denies the claim. Quote, he is emotionally abusive and the applicant feels extremely insecure and anxious, unquote. This is perjury and slander and is most strenuously denied as the lie it is. 4. Witness. Our then 26-year-old son was living in our house, recovering from cancer. Should the jury wish to subpoena Jared Robinson so as to testify that his mother was living in extremely comfortable circumstances, then you are most welcome and most encouraged to do so. A man of 26 who has just survived cancer, who said, quote, you have been the best stepfather a man could possibly be, unquote, is not about to allow his stepfather to be, quote, emotionally abusive, end quote, to his mother when he is living in the same house. That claim does not stand even the most modest of inquiry. Like, who else was living in the house with you at the time? Oh, your 26-year-old son was living in the house with you at the time, and you claim that your husband was being emotionally abusive to you in front of your 26-year-old son. Let's get the son in here and ask him that question. Doesn't stand up to any scrutiny at all. 4. Principal denies the claim. Quote, the respondent has always been very controlling and critical of the applicant. In his view, everything she does is wrong. He constantly undermines her. This has resulted in a severe lack of communication between the parties. Essentially, they now lead separate lives. End quote. This is a pack of lies that constitutes the crime of perjury and slander. Again, should the jury wish to hear from the 26-year-old son that was living in the house during this period, where there are such claims, that you are most welcome to subpoena Jared Robinson to witness my testimony that I was one of the very best possible husbands and fathers. 5. The principal denies the claim. Quote, the respondent unilaterally withdrew the sum of €10,000 approximately from the parties' joint account in Jersey without notifying the applicant. End quote. This is a lie which will be dealt with in a later affidavit. This lie is proven at law because I have evidence from the bank manager involved that the transfer mentioned was performed in error. Principal also makes oath that said €10,000 was applied to the benefit of the family and was not used for personal expenses or personal advantage. Okay. 6. Principal denies the claim that, quote, he has endeavoured to compel the applicant and the children to return to Australia, end quote. This is not the nonsense of this claim is clear for all to see. There is no way any man can compel an adult woman and 2 children aged 14 and 16 to go through airport security for at least 4 airports, and anyone with a brain knows that such cannot be done. But here it is on an affidavit. The claim that a man can somehow compel such actions despite the very heavy security presence of armed guards in most airports now is ludicrous. 7. Principal notes that the following statement is made on this affidavit. Quote, I say I have literally no money and I have been reduced to scraping money together from the money boxes of the children. End quote. That's what she said. My response. The parties had an estimated equity of $500,000 in the property of 8 Schofield Parade, Pennant Hills, New South Wales 2120, Australia at this time. Principal discussed with the bank holding the mortgage, being the St George Bank, that some of that equity be reloaned to both parties to pay legal fees during this dispute. The bank agreed this would be a simple matter as we had an estimated 65% equity in our house. The mortgage at the time was $225,000 and the estimated market value was approximately $700,000. Please remember this was November 2007 at the height of the Sydney property market. Respondent was asked to release some equity from the house and flatly refused to do so. She insisted on borrowing money from her elderly retired father rather than to use the money that she had gained by breaking her oaths to me, her husband. Therefore, respondent was pretending to be, quote, poor, end quote, so as to further slander principal, and this is a fact that is not up for debate. Principal can, if respondent challenges this point, produce the email trail of her refusing to allow an increase in our loan amount of our mortgage. Principal also notes into evidence for the jury that this, quote, penniless, unquote, woman then relocated to a new house in a gated community in one of the most expensive suburbs in Dublin called Foxrock. The jury might wish to compel the respondent to answer where she got the money to move to a new house in Foxrock. 8. Further, in February, the family car, an old Volvo, was for some reason no longer in use, and respondent acquired a new second-hand car. The jury might wish to compel respondent to answer the question as to where she got the money to buy another car if she was scraping money together out of the children's money boxes, as she claimed she was doing under oath. Okay. Bullet 9. Principal notes the following statement is made on an affidavit dated 2007-1207. Quote, I say that he has cancelled all direct debits for the running of the household here in Ireland. I say that he has cancelled direct debits for the children's school fees, health insurance, and there are insufficient funds to discharge the rent on the family home, end quote. These are lies and constitute the crimes of perjury and slander. I have a letter from the relevant bank manager that states that the bank cancelled these direct debits and that I was informed after the fact. The reason the direct debits were cancelled was because the account was about €8,000 overdrawn, and there was no prospect of timely payment of the overdraft because of the vicious and unwarranted attack of respondent on principle, using the criminals in the legal system as her own brown shirt thugs. This count of perjury is proven, and the proof of the perjury will be presented in later evidence. Now, I also just want to make the point that Jennifer seemed to have a remarkable amount of money available to her, and I would suggest that the jury also subpoena Jennifer to find out if she had other hidden bank accounts. It is my contention that she was stealing money through the entirety of the marriage. Okay, and we will need to find out if that is true or not. Did she steal money during the entirety of the marriage? Item 7. That is perhaps a question the jury would like to ask her under oath. Item 7. Principal makes oath that respondent had his bank accounts frozen based on her perjury. As a result, principal was cast into poverty and was reduced to begging for money from family and friends because his access to his property was violated by the criminals in the Australian and Irish family courts. Item 8. Principal makes oath that during this period he was required to borrow in excess of €80,000 from family and friends so as to defend himself from the vicious, malicious, unprovoked and unwanted attack from the criminal respondent wielding the criminals in the legal system as her own brown shirts. Item 9. Principal makes oath that at the end of 2007, Principal wrote to respondent and the lawyers for the respondent and made it very clear that should respondent relocate the alleged children of principal to any other living arrangement, that principal was to be informed of the address and telephone number. Any failure to do so would be considered the crime of kidnapping, meaning the removal of children to places unknown without the express consent of the parent. Item 10. Principal makes oath that during the month of February, I cannot be sure of the date as I was not informed, the respondent moved the alleged children of the marriage to places unknown, thereby committing the crime of kidnapping. Respondent has never denied this crime. Item 11. Principal makes oath that during the month of February 2008, respondent did abuse an elderly and ill woman, being my mother, who was slipping into dementia, by refusing to provide my father with the telephone number of the grandchildren so that my mother could speak to her beloved grandchildren at a time when she knew she was slipping into dementia. My mother was living in Wagga Wagga and the children were in Dublin. Item 12. Principal makes oath that during the month of February 2008, I had to sit and watch my mother cry many times as she begged me to do my best to get a phone number to speak to her beloved grandchildren. Okay, under oath. Note to the jury. Yes, you heard that correctly. The respondent is such a hate-filled, greedy bitch that she refused to give an elderly and ill woman a telephone number on which she could call her beloved grandchildren, even though my father, John Thomas Nolan, gave her father, William Toal, his word that he would not give said telephone number to me. The respondent you are dealing with is that much of a hate-filled, vindictive, nasty, greedy bitch that she would abuse an elderly woman for money. That's what she did. She abused an elderly, ill woman for money. And if you do not believe me, then you ask her yourself if that is true under oath. I have plenty of witnesses to that statement, not least of which are John Thomas Nolan, William Toal, and Jared Robinson. Item 13. Principal makes oath that during the period of approximately November or December 2007, Principal insisted on a paternity test for both children, then 14 and 16 years of age, so as to unquestionably establish paternity. Principal notes that in Australia, no child support can be ordered without a paternity test proving the paternity of the alleged father. Respondent unilaterally denied the paternity test. By doing so, respondent waived any claim to any financial support or otherwise for her children. Note, her children, as there was no evidence that they were the children of the principal. No evidence ever presented that they were the children of the principal. Okay? So when you come to the statement by David Dunkley that sent 70, where he said 70-30, but sent 95% of property to the respondent, he had no right to do that. One, because he had no jurisdiction, but two, there was no paternity test. Okay? So the arguments about the woman was taking care of the children and needed more money for the children are null and void because there was no paternity test. Okay? Item 14. Principal makes oath that the behaviour of the respondent and her family was a total, complete and utter disgrace for the entire period from November 2007 until present. Michael Toal, respondent's brother, has been slandering me widely for more than 2 years now and has used his connections with ASIO to threaten injury, harm and loss to those who are associated with me. William Toal has refused to maintain law and order in his family. Indeed, William Toal has joined in the criminal actions of his children by endorsing and supporting their actions, by loaning respondent money, as well as failing to restrain his son, Michael Toal, from slandering me and threatening others. This has carried on to such an extent that Principal has now placed Michael Toal on the active kill list for Australia and recommended to William Toal that he have the New South Wales Police forcibly restrain Michael Toal in a mental health facility due to the very clear mental health issues that Michael Toal has. Michael Toal may not be harmed if he is in a mental health facility. While secure in a mental health facility where he can cause no injury, harm and loss, he has the protection of the law. While walking the street as a man accused of committing war crimes in Afghanistan, a man who is openly threatening people, a man who is a marksman of sniper level capability, a man who is very well trained in martial arts, he can be killed on my word because due to his clear mental health issues, he is a clear and present danger to those people assisting me reintroduce the rule of law in Australia. If anyone has a problem with me doing this, they are welcome to put their issue in writing and send it to me. If the New South Wales Police were doing their job, we wouldn't have to do this. Item 15. Principal makes oath that when my children were kidnapped, I demanded that my right to my alleged children as father be immediately restored, and the respondent was charged with the crime of kidnapping. That's what I demanded. Principal was advised by Pierce Neary, my Irish family law lawyer, that if I had done the exact same thing, I would get about 5 years in jail. And Pierce noted that there were quite a few fathers jailed in Ireland for kidnapping their own children. Pierce Neary told Principal that in Ireland it was not considered possible for a mother to kidnap children, and no mother is ever jailed for kidnapping, quote, her, unquote, children. That's what I was told. I make oath to that effect. Since the children were also subject to what I believed was Australian law, I queried Jacqueline Vincent of Watts McRae Lawyers as to what could be done about the crime of kidnapping. The answer of Jacqueline Vincent was that there was nothing a father can do when a mother kidnaps a child. Indeed, I was to later find out that in Australia, women are never prosecuted for kidnapping the children and are never prosecuted for refusing to obey court orders because the legal fraternity are a criminal cartel that allow women to commit crimes with impunity. Hence the very fact that we are creating new courts of law for Australians, because the existing courts of law are a criminal cartel, as evidenced by the fact women are not held accountable for their crimes in them. Item 16. Principal makes oath that in the face of the almost universal acceptance of the allowance of the violation of my rights as a father, and in the face of much hatred from men and women alike for standing up for my rights as a father, on the 8th of March 2008, I took the decision that I would protest this blatant violation of my rights as a father and the almost universal support of the community by disowning my alleged former children and walking away from them. My message to my community, that is you people listening to this, my message to my community is clear and unequivocal. Given my community supported and condoned the violation of my rights as a father, my community did not deserve to have me be a father in that community. The community can do without the benefit of my labour and presence as a father. If fathers are to be treated so badly as I was treated, the community does not deserve to have men like me choose to be fathers. They can do without and see how that works out for them. Okay? And I say that under oath. And you people in my community want to listen up. Or listen up or not, up to you. I cannot be compelled to be a father. Item 17. Principal makes oath that I now give the following advice in my own name, in the public, as to how to deal with the violation of their God-given right to be the father they choose to be. This is the advice I give to fathers. And you, the jury, want to listen closely to this, because I have told thousands of men this is my advice. And this is what I did. My advice is as follows, and I say this under oath. And I say this under oath, meaning I have told many men to do this. This is my advice. 1. Disown the alleged children and refer to them as your former children. I did that. 2. Refuse to cooperate with your criminal victimization in any way, shape or form. And I did that. Refuse to pay any money to any person claiming that you have any obligation to the mother or the children, because they are not your woman and not your children. You do not own them, so you do not have to pay for them. You can have no obligation to pay for anyone or anything that you do not own as property. Okay? You cannot have any obligation to pay for anyone or anything that you do not own as property. You can choose to pay for people you do not own as property. The only people you have to pay for are slaves. The violation of your rights and your authority in your family breaks any obligation you may have chosen to undertake as a father and husband. Okay? If it's not on a contract, it's not an obligation. 4. Openly and publicly promise to kill any person who attempts to enforce slavery on you. And that's very controversial, and I'll say it again. And I did this. 4. Openly and publicly promise, not threaten, promise to kill any person who attempts to enforce slavery on you. That is my advice to men. And now, 5 years later, when there has been no path to justice possible for a man like me for a period of 5 years, I absolutely openly make the statement that men should openly and publicly, in their own name, promise to kill any person who attempts to enforce slavery on them. Men have a right of self-defense, as much as the rest of the community would like to deny them that right and violate that right. Now, under oath, I make absolutely no apologies for giving this advice in the public in my own name. This is exactly what I did. If every father did the same, then their rights would not be violated. That I have waited more than 5 years for my path to justice demonstrates that there is no peaceful path to justice available, so self-defense using force is necessary. Now, you, the jury, may decide that I have a peaceful path to justice available to me, supported by the community. If you decide that, then the use of deadly force is not necessary. If you decide I don't have a right if you decide that the community is not willing to provide me a community-supported path to justice, then I have a right to use deadly force under natural law. As does every other man have a right to use deadly force to defend his life, liberty and property under natural law. Just exactly like any spider, poisonous spider in Australia, just exactly like a death adder, just exactly like a tiger snake. In Australia, if you go waltzing off into the forest, you might just run into a tiger snake. You might just run into a taipan. You might just run into a death adder. If this animal feels threatened of injury, harm and loss, it might just bite you and you might just die. So, under natural law, men are certainly not lesser than snakes, right? And if we're not lesser than snakes under natural law, we have every right to defend ourselves using any means we see fit, just like the average redback spider, or trapdoor spider, or death adder, or tiger snake. Okay? And I will brook no complaint about that. If somebody wants to complain to me about that, they are welcome to complain to me in writing to my email address, and I will post it to CAF with my comments. 18. Principal makes oath that on the 1st of April 2008, I started the process of disowning my former children. Because I loved my former children very much, this was a very difficult thing to do. The plan was to sit on my balcony every night and listen to music that reminded me of my former children, so as to get very present to how much I loved them. Following that, I would work to sever my relationship with them while listening to the same music over and over again. It was a process of desensitization, rather like hitting your hand with a hammer. It feels good when you stop. Under oath, I quickly slipped into depression and then into a state of being suicidal. I would sit on my balcony on the 5th floor all night, considering throwing myself off the balcony each night, all night. I would drink strong alcohol and sometimes smoke up to 2 packets of cigarettes per day during this period. I can honestly say, under oath, that some mornings or even afternoons, when I woke up on my bed or the couch, I was genuinely surprised to be alive. Pleasantly surprised too. Item 19. Principal makes oath that on the 1st day of May 2008, I attended a May Day party with a friend, and at this party I had my first quote, future thought unquote in a month. It was at this party that I realized I had come out of my suicidal phase, that I was actually going to survive the process of disowning my former children. Item 20. Principal makes oath that it was only at a later point in time that I realized that many men killed themselves as a result of the vicious, cruel, callous, vindictive and unconscionable treatment women lash out to the men they claimed to have loved via the criminals in the family law courts. One claim was that if you counted, quote, death by alcohol and drugs, etc., as also being, quote, suicide, unquote, then the case could be made that some 4,000 men kill themselves every year in Australia as a result of being criminally victimised by women wielding the criminals of the family law courts. That claim was made on the Dads on the Air site in Australia. The very fact that we do not even count these men tells you, the jury, how little regard men are held. I want to repeat that. The very fact that we do not even count these men who kill themselves, we do not even count them, tells you, the jury, in how little regard men are held. When they kill themselves, we don't even bother counting the bodies. It is a disgrace. Note to the jury. You, the jury, have the authority to decide what to do about conduct so unconscionable that it drives men to suicide. I had a colleague at Hitachi Data Systems, a colleague Jennifer knew, by the way. I had a colleague at Hitachi Data Systems who killed himself when his baby girl, just a few months old, was stolen from him by his wife in 1997. We did not realize what was happening, and we were not able to save this man's life. Once I had been through the process myself, I realized full well what deeply evil people women like Jennifer Marguerite Toal are. I made it my business to put an end to their deeply evil deeds. You, the jury, are the people I am asking to put an end to the deeply evil deeds of deeply evil women like Jennifer Marguerite Toal. I can assure you that if you do not do this, the rate at which men are killing women and children in divorce, already high, will go higher still. The very fact that, quote, we the people, unquote, living in the lands of Ireland and Australia, have refused to provide me and many other men with a path to justice is creating a hyper-violent society. And you can see it in your newspapers every day. This is the agenda of your government and your politicians. They want a hyper-violent society. That is their agenda. We, the people, are required to cooperate to stop that. If you want to stop the evolution of the hyper-violent society, then you, the jury, have to send a clear message to the women and to the government that you will hold criminals accountable for their crimes. That's what you, the jury, need to do if you want to stop the evolution of the hyper-violent society. Stopping deeply evil women like Jennifer Toal from committing their crimes is actually in the best interest of all members of Australian and Irish society. I recommend you take this point into consideration as you discuss this case. Item 21. Principal makes oath that during the months of May to September 2008, I slowly recovered myself from being suicidal. It was a difficult period made easier by 3 new friends who helped me through those tough times. Further, Principal makes oath that I decided to deconstruct my entire identity of who I was and what I stood for, and to create a new identity from scratch. I chose to no longer be a, quote, husband and father, unquote, because it had been made very clear to me that husbands and fathers were no longer valued and no longer treated with respect. Therefore, I would no longer pursue this way of being in the future. Remember, I'm saying that under oath. Note to the jury. I also took it upon myself to tell other men, young and old, exactly how badly men are treated in divorce. To my great astonishment, many people simply did not believe my statements. One reason I have released this affidavit of accusation and I have published all the documents related to my family law cases is that this affidavit and the related evidence provides the irrefutable evidence of the blatant criminal victimization of men in the family law courts in Ireland and Australia. This evidence needs to be placed into the public for all to see. Someone had to stand up to the criminal women and the criminal legal fraternity, the criminal politicians. Since there did not seem to be any other man willing to record everything, publish everything, and tell the criminals openly and publicly in his own name that he would kill anyone who tries to force slavery on him, I thought that man might as well be me. The truth had to be told for the benefit of all. That I have been persecuted by the very people I set out to help in May 2008 has been something of a disappointment. However, because of my efforts, you, the jury, now have the chance to set the record straight. And you have the chance to set the standard in the future with respect to whether men and women will be treated as equal before the law in Australia. If you, the jury, decide women are to be able to commit these crimes with impunity, then you must accept that men must also be allowed to commit similar crimes with impunity. If you, the jury, attempt to maintain the current situation, that men are offered less protection of the law than a stray dog, you may do so. It is your choice. But I would caution you that your decision will mean men will take the law into their own hands and dispense summary justice against women criminals who victimize them. That is my warning to you. That is my caution to you. If you do not give men the protection of the law, many men are already killing women and children in divorce. If you do not make a stand and give men the protection of the law, the blood of more women and children will be on your hands. Okay? You don't have a choice about that. That's what will happen. I would remind you that absent the protection of the common law, the decision of a jury, all men have the right to natural law, the law of the jungle, the law of survival of the fittest. You, the jury, can extend the protection of the common law. You cannot withdraw the jurisdiction of natural law, since we are all a part of nature. If you fail to protect men, they will kill more women and children. Sorry for the ED. So my message to the jury is simple. If you fail to offer the protection of the law to men, as you are being asked to do, in a community-supported fashion, men will kill more women and children. The rate at which women and children are being killed in divorce is rapidly escalating in the West, particularly the US. And that is a sign of things to come in Ireland and Australia. Item 22. Principal makes oath that during the month of June 2008, I took an oath to reintroduce the rule of law into Australia and Ireland so that other men might be spared the experience that I just went through. In May and June, I had become aware of how many men kill themselves in divorce, how many children are left to grow up without a father, and how vicious, cruel, vindictive, callous, and hate-filled our Western women had become. That's what I came to understand in May, June 2008. The reason I had come to understand that, I had started a relationship with an Eastern European woman, and in doing so, the level of hatred and sheer evil perpetrated so commonly by Western women had become apparent to me. Okay, that's why I realized it. I had something to compare Western women to. I took an oath that I was going to put an end to these blatant, evil, criminal victimization of men by our Western women. The very fact that Western women and men have fought me every inch of the way, every step of the way, is an indication of just how evil they are. The vast majority of Western women and men do not believe in equality before the law. That's a fact. (23) Principal makes oath that during the months of June 2008 and October 2009, I studied as hard as I could and learned as much as I could from as many people as I could as to how the criminal legal system actually worked. I learned from the most knowledgeable people in the world. We performed many tests in many courts around the world. Some of my colleagues were arrested and jailed by the criminals in the legal fraternity and police during this period. But brave men went forward willing to be arrested, beaten, tortured, and even killed so as to break the grip of the criminal politicians, legal fraternity, banksters, and police on society. Yes, I mean that seriously. Some of us went forward knowing that we might be killed, just like your average foot soldier. Item 24. Principal makes oath that the plan I had prepared in order to, quote, do my bit, which is a very common saying in Australia, do your bit, do my bit, unquote, like every brave Anzac before me, and borrowing the analogy further, was to charge directly into their line of fire and attempt to get the criminals in politics, the legal fraternity, the police and the banks to criminally victimise me as much as was possible, so that at a later date I would be able to run my cases in new courts and gain remedy for the crimes these people committed. That was the plan. Many noted that such patriots often end up dead. My reply was that, quote, I have died once already and it wasn't that bad. Every day above ground is a bonus for me now, end quote. I said that to quite a few people. So, quote, storm the enemy lines, unquote, it was. I am very proud that when I do die, I will take my place next to my step-grandfather, Frank Trainer, who was an Anzac in World War II. I am already assured that when I die, I will be welcome in the ranks of Frank Trainer and his fallen comrades. That is good enough for me. There will be very few men of my generation welcome in such esteemed ranks. Principal makes oath that in late November, the 23rd or so of 2009, I flew from London to Sydney and took up a room at a hotel in Parramatta, Sydney, to prepare for my scheduled court meeting with whoever would turn up on the day. I did not know if the person who would turn up would be Louise Henderson or David Dunkley. I had warned David Dunkley that I had no argument with him, that he was very well advised not to sit on my case and allow Louise Henderson to suffer the results of her own actions. In short, I told David Dunkley to, quote, keep out of my business for his own benefit, unquote. He chose to insert himself into my dispute. That was his choice, against my expressed written advice. Item 26. Principal makes oath that on the date of November 24th, 2009, I went to the Australian Federal Magistrates Court in Parramatta, Sydney, and spoke with a man who called himself Paul Lalage. Paul claimed to be the registrar for the building and the courts. I wished him to deliver a set of documents to both Louise Henderson and David Dunkley. These were a copy of the documents that I would bring with me on the Thursday, 26 November 2009 to my court meeting with whoever turned up. Paul and I discussed this situation for a period of about 15 minutes. Paul refused to give me his word he would deliver these documents. Paul Lalage has a case to answer for as well, and we will get to him in good time. Principal makes oath that he had served affidavits on respondent on 2009-09-09, 2009-09-09, knowing that he would see respondent in the court meeting and would be able to serve default judgments on the respondent in the court meeting. These affidavits and the default judgments will now be read into this affidavit as evidence. They are available in the attachments as follows. So what you're going to see now is a transition to read all these things into evidence. And I'm going to end this section, this first section of this reading the evidence into the public record and onto the jury record. And we will start another section after this. So this concludes section 1, and it will now transition to the reading of this evidence. Thank you.